So good evening. Thank you all for joining us for tonight's chatting with Natalie. And what we're going to be doing is Natalie's going to be speaking for a bit, then having a break halfway through for questions, and then doing the second part of the talk, and then there'll be more questions. Okay, so that's the basic structure of the evening. I'm going to hand over to Emma to just talk a little bit about the charity. And then I will introduce Robin, I will introduce Natalie and we'll kick off.
Thanks, Mim. So this is just my opportunity, as usual, to do a little bit of a plug for the charity and just remind everybody why we set up Adult CP Hub and how today's chatting with links to some of our objectives. So Miriam and I set the charity up in 2018 because we felt that there really wasn't a charity that was dedicated specifically to adults with cerebral palsy, and that what we'd realised was that there was very little understanding about cerebral palsy as a lifelong condition. And many of you have followed us on our journey, and you'll know that we're trying to work in three very specific ways. One, we're trying to act as a support mechanism for the community where we can, particularly during the pandemic. Two is about giving a voice to the community, and that's all around the lobbying work that we're trying to do with government to try and change the understanding of cerebral palsy with the medical practitioners and with policymakers so that we can have better healthcare. And third is that we really believe that as adults with cerebral palsy, we're entitled to understand our condition in the best way we can and empower the community to look after themselves so that they can all live their best life. So where we can, we want to be able to impart new information and the information that we're receiving about what the best way is to look after yourself. And that's really where this evening came in. We had an evening a few weeks ago with Kirsty Parkinson, and she was talking about the Care Act. And Natalie has kindly offered to come this evening and talk to us a little bit about our rights in relation to the Equality Act. And I would like to thank Natalie for doing that. She's got a background in this area, and so I believe that she is going to give us some words of wisdom.
Brilliant. Thanks so much, Emma, for updating us and just really reminding us all about the charity and the importance of what we're trying to achieve. I'm going to introduce Natalie now. So Natalie has worked in the charity sector for just under 10 years, 5 of which have been for the disability charities, and the last 4 in a disability-led organisation. In her current role, she uses the Equality Act and social model of disability to underpin the organisation's work to bring about equal access to the live events industry for deaf and disabled people. Over to you, Natalie. Thank you very much.
Thank you. So I think the first thing that I just want to share is basically just to state that obviously I will be talking about the Equality Act today and going to be giving advice on how it will help people or help you as a disabled person. But I just want to kind of cover my own back and just say that this isn't legal advice. So it's just kind of stuff that I've picked up along the way using the Equality Act day to day in my personal and professional life. So yeah, as Miriam said, I use the Equality Act pretty much on a daily basis with my work in the music industry. So as well as professionally, I've also used the Equality Act personally too. So like many of you on this meeting today, I've got CP and my lived experience is one of the main reasons I'm so passionate about not only, you know, the work that I do, but also it's a big reason that I'm such a strong advocate for speaking out about things when they're not quite right. So I just wanted to start by explaining the social model of disability. As Miriam states, this kind of underpins the work that we do, and the social model forms the basis of the Equality Act. But to be able to explain the social model, I need to just explain another model of disability first. So the first one I'm going to explain is the medical model. And the medical model of disability says that people are disabled by their impairments. In the medical model, disability is a problem and the solution is to cure or fix the disability. So the medical model looks at what's wrong with the person and not what the person needs. And this obviously will create low expectations and leads to people losing independence, choice, and control in their lives. So that kind of gives you one view of disability, and this is just going to bring us on to the social model. So this is a way of viewing the world which is created by disabled people and for disabled people, and I think that's the real kind of key difference here between these two models of disability. This model is the model that kind of forward-thinking organisations are using or working towards. So the organisation I work for and other arts organisations, voluntary organisations, social services, the NHS, and loads of other kind of public bodies are now working to. But what does the social model actually mean? The social model states that disability is the experience of barriers. So these barriers can be physical, like buildings not having accessible toilets, or they can be caused by people's attitudes, like assuming disabled people can't do certain things. So when we as individuals and as a society begin to reduce and remove these barriers, disabled people therefore become far less disabled. So the social model is based on the person and not the impairment. So a couple of examples, under the medical model, I can't go to the new shop in town because my disability prevents me from climbing the stairs. But then under the social model, I can't go to the new shop in town because the steps prevent me from entering the building because the staff believe me, a wheelchair user, to be a fire hazard. And under our current laws, I have no right to challenge the current situation. So this would be where the Equality Act would be able to step in and enable you to challenge that situation. So in this example, requests that steps are replaced with a ramp. So I'm just going to talk a little bit about the background of the social model, of the Equality Act. That's what we're talking about today. So I'm sure, as most of you know, the Disability Discrimination Act, known as the DDA, preceded the Equality Act. The DDA came into effect in 1995. So last year it was celebrating 25 years since its inception. To this day, there are actually still organisations that use the term DDA compliant. For example, businesses might describe their accessible toilet as being DDA compliant. But I just wanted to point out as a kind of side note that this is now outdated and technically has no meaning behind it, as the DDA has been replaced by the Equality Act. So I just wanted to point that out, as if you see that, please do bring it up with the business, as they need to clearly be brought up to date. Plus, accessible toilets don't need to meet the Equality Act per se. They need to meet Building Standards Part M, but that's a whole different story. I could do a whole other talk about Part M. But I just guess what I'm trying to say is that if a business says that they are DDA compliant, they need to brush up on their disability awareness and their knowledge of disability legislation. So that's great. That's why all you guys are here today, to brush up on your disability legislation. So please share the knowledge with businesses and other people. So just going on to look at some key dates between the DDA coming into force and now. So since 1995, put simply, it's been unlawful to treat disabled people less favourably than other people because of their impairment. And since the 1st of October 1999, service providers have had to make reasonable adjustments to the way that they provide goods, services and facilities. And I'll explain what I mean by reasonable adjustments a little bit later on. Since 1st of October 2004, service providers have had to make reasonable adjustments to the physical features of a building, and this covers all buildings, both old and new. And from the 1st of October 2010, so last year celebrating 10 years since it came into force, the Equality Act replaced the Disability Discrimination Act, and it brings all the former Equalities Acts together under one new act. So just looking at some definitions, if you like, under the Equality Act, people are protected from discrimination on the grounds of various different things. And these are known as protected characteristics. So these things could include race, sex, sexual orientation, being married or in a civil partnership, or of course, disability. So the stuff that I'm talking to you about today is quite heavily disability related, but do bear in mind that there are other things that you may be protected of under the Equality Act as well. So the Equality Act aims to protect disabled people and prevent disability discrimination. It provides legal rights for disabled people in the areas of employment, education, access to goods, services and facilities, and buying and renting land or property. So the definition of disability under the Equality Act has not changed from the DDA. In the Act, it's stated that a person has a disability if they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on their ability to perform regular day-to-day activities. It's quite a mouthful. So if we look over those 2 points, the first one, a physical or mental impairment, it's pretty straightforward to understand. It's just one simple statement. The second point, for the purposes of the Act, these words have the following meaning. So substantial means more than minor or trivial, and goes beyond the normal differences in ability which may exist between people, which is of course very, very clear. I think you will agree. And long term means that the effect of the impairment has lasted or is likely to last for at least 12 months. So that's something that's really important to remember. So, if someone is saying this isn't, I've got a broken leg and you need to put these reasonable adjustments in place, then actually under the Equality Act, that doesn't need to be done, because a broken leg is healed within, I think it's 6 weeks or something like that. So that's just something to bear in mind. And the next part, regular day-to-day activities. Now this basically includes anything. So things like eating, washing, walking, going shopping, just to name a few. When I talk about the Equality Act at work, we obviously, of course, including that, going to gigs and going to festivals, doing social things also counts in this. But yeah, this list is pretty endless. I could probably do a whole hour just on these day-to-day activities. So the list of people that need to be considered when making these adjustments are wheelchair users, people with mobility impairments, visually impaired people, hard of hearing people, deaf people, people with invisible impairments, people with learning disabilities, people with mental health conditions and progressive conditions. So it's just to give you an idea of when we talk about disability, who is included within that list under the Equality Act. Obviously, this isn't an exhaustive list, but it's just useful to know kind of who's included in it. But yeah, I don't understand how, but we're already at the point where I just want to pause because I'm talking at you a lot. And I just want to see if anyone has any questions so far. So it's been a bit of a whistle-stop tour of the social model of disability, background of the Equality Act, and definitions under the Act. Does anyone have any questions?
Yeah, Nat, can you just, you talked about who was protected under the Equality Act, and that's fairly straightforward. Can you just go over again the areas that it's covered? So that
like employment and
yeah.
stuff like that. Yep. So it's basically covers a lot of different areas, but so it's like employment, education, and access to it. It states under the Equality Act, access to goods, services and facilities. So that basically is a tiny statement, but obviously that's anything. So that could be going to the shop, that could be going to your local gym, going to a night out in a nightclub, the list is pretty endless. And then also buying and renting land or property as well.
So from that point of view, I'm sure you're going to cover it later on, but just does that mean that literally every place within society that we interview should have a policy or should have something, whether it's a shop or like you work within concerts or sports arenas or anything like that, they should all have that policy in place.
So it would be not necessarily a policy, but to be able to meet their obligations under the Equality Act, it's all about reasonable adjustments. So it's just so like the example I said about the shop, if someone wanted to come to a shop, but there was a step and they couldn't access the shop because of the step, a reasonable adjustment would be to replace that step with a ramp. So it would be just being willing, and this is the kind of biggest barrier, if you like, that a lot of companies and organizations generally aren't willing to try and help. But what I'm hoping to do today is to empower people that if they do see things that are not right or things that can be changed, I mean, a ramp is probably 50 quid to put in front of a shop. So it's just about empowering and speaking up, because I talk about it a bit later on, but if organizations don't have that lived experience or don't know anyone with a disability, they may not even notice these barriers. So I think that's just something to bear in mind, and just to kind of work with the businesses.
Brilliant. And we've got a couple of other questions. People want to ask their... Anna, do you want to come in with your question?
Yeah, hi.
Hello.
You listed some of the conditions that the Act covers. It's learning disabilities. What about learning difficulties like dyslexia?
Dyscalculia? They're covered as well.
Covered.
Yeah.
And I've just got another one. My council is quite keen on saying, oh no, to the shops, you can't put a ramp in because that's too dangerous for other people. They might trip over it because it's a historic town and the pavements are really, really narrow. So the shops are willing, but the council is refusing to let them.
So this is one of, it's probably quite sad of me to say, but this is probably one of my favorite things that we come across all the time. Basically, if someone from the council says that, then it needs to be in writing. So they would need to get an access audit done of the building, and access audits, that's something that we do at work as well, so I'm experienced with that as well. That includes the outside of the building and the approach to the building, so that kind of area would be covered. And it's just, once they've had the access audit done, what an access audit does is looks at ways that the building can be improved. So if there's a ramp that they can put in place, then they will find ways to put that in place. And an access audit kind of overrides what someone from the council says. Do you see what I mean? So yeah. They couldn't just say, no, you can't do that. They'd need to have, there might be times when an access audit might say, actually, health and safety, this probably isn't great to have a ramp here, but you would need to have that paperwork that says that. It couldn't just be a kind of blasé, no, you can't have that here.
Oh, thank you. Yeah.
That's all right.
There was another question from Benny. You might need to come off mute.
Sorry. Yeah, you was talking about promoters and venues. I'm a comedian now. I can walk in a fashion, but is it the pub that should make sure there's wheelchair accessible, or should the promoter do his gig, he or her, should they make sure it's accessible to everyone?
So that is Again, this is a great question because this is what I do every day. So thank you. So basically, that's a bit of a two-way street. So we work directly with venues. So primarily, it would be up to the venue to put that in place. But we do also work with promoters as well. So if you can get both of them kind of on the same page, but obviously that requires conversation. And what we tend to say is that and I'm sure if you've got experience of it, promoters and venues don't really like to talk to each other. But what we tend to suggest is that the venues do include access within their advancing and stuff like that, so that the promoters know what's there and they can start that conversation.
Well, all I get is that's the only pub who will have us, which I think is stupid. So
yeah, so definitely go to the pub directly and talk to them and see what they can do. But from the promoter's side, if the pub isn't accessible, and then that would be down to the promoter to then look for another space.
Yeah, thank you.
It's all right.
We have another question coming in from Dave. Just trying to. There we go. There, Dave.
Oh, yeah. In terms of like arenas and performances and things, it's always been because like Leeds Arena is like a relatively new build, obviously, and I've been to Sheffield Arena prior to Leeds opening, and that had a handrail right down the middle, so I could sit wherever I wanted in Sheffield Arena. But like Leeds Arena, I always have to ask for like ground floor seating or whatever, because there's no handrail. So if you need something to help you balance to get upstairs, it's hopeless. And like the first few times before I realised that, I used to sort of get the stewards to help me. But I just wonder, I've always have wondered really how a build like Leeds Arena managed to get something through that wasn't great for accessibility.
So they should have had a access consultant on the team. This is again another real bugbear, because it's not a legal requirement to have an access consultant and an access audit. So that's obviously something that we're championing for, to have that in place. With the arenas, the work that we do, like I'm happy to put my work email in the chat if that's helpful. And basically drop me an email and we work with the venues. So we would help them to have like a decent online access information, so that you know what to expect and any kind of workarounds that they may be able to put in place for you. But if that's helpful, I can put my work email in the chat and you can send me an email.
Yeah, I mean that's great, but I mean I've just got used to asking for seats as low down as possible now. But I just if you want to put your email in the chat, that's great. But I just wondered, sort of more than anything else, how they managed to get that through with it being a relatively new build. But that's kind of answered it anyway. So cheers.
No worries.
And we've got one more question from Claire Duffett. You might need to come off mute, Claire. There you are. You're off mute.
Thank you. So I was going to ask about access to work, because back in the day, access to work used to do major renovations of places and things. I've worked for a small business who were certainly willing in terms of their attitude towards disability, but up until me, they'd had a lot of more, if you like, mental disabilities, so autism, or staff with autism, that sort of thing. I was their first wheelchair user. and I was having difficulty with things like the doors. And access to work, and I also had some deaf colleagues, and they needed like the flashing fire alarms, but those kind of things are really expensive. Access to work said that because there were structural parts of the building that everybody used, they couldn't fund it. But as a small business, the business couldn't afford it. So
with access to work, that is right. So what they've said is correct. Unfortunately, because it's a reasonable adjustment, and although it is a small business, they could do things like fundraise for it and things like that, because it is down to the business. It's not down to the disabled person to put towards it. It's down to the business. And if access to work can't help with that, because I use access to work, but it's for personal things. So like my chair that I'm on, because I'm working from home, just to kind of clarify that. And it's all personal things. So it's just for me. But because it's structural, it would be something that they would need to, there could be funding streams that, I don't know what kind of business it is, but there may be funding streams that may be able to help as well.
But then the barrier is, some employers might say, well, we're not going to raise money for that, or we're not going to pay for that unless we know you're going to be here a long time. Under
the Equality Act, they can't do that. So
it can be difficult to persuade. I'm just saying, or particularly say somewhere's got a stairs and it needs one of those roll up the stair lift things. You need that put in place in order to start the job. And then that makes companies less willing to take you on, because they want someone who can get started straight away. And that can make it really difficult, especially for like temporary jobs and things like that.
Yeah, no, I appreciate that. But that would be, like I say, I'm not I was going to say a legal person. I don't know.
No, sorry, I'm not trying to.
But I'm just the solution would be to talk to them about the Equality Act and say that the what you're doing is against the Equality Act and it's discrimination because of X, Y, and Z. And if you wanted to take it further, you could take it to court. But it's one of those things, so a lot of businesses, you might say, not threaten them with court, but you could say, this is against the Equality Act, I want to take this to court. And then they'll say, oh, okay, let's put it in place, because it's about being, for want of a better way of putting it, it's about being really vociferous and really like strongly, which is, I know it's really hard because it should be in place anyway, which is really frustrating, but it is really about just being really empowered and saying that this is wrong and this is how you can fix it. And even, I know, access to work have said they won't fund it, but talk to them and ask them, okay, you won't fund it, but can you tell me of other organizations that may be able to help out? Because like I say, depending on the type of organization that it is, so obviously my expertise lies in music venues and arts organizations. If it's one of those, I could tell you where to go to get funding, but because I don't know,
But as I say, that's where it was so frustrating, because on this occasion, the employer had the right attitude. They liked to employ disabled people. They wanted to have all things in place, but they just didn't have the budget in their finances to put those things in place. And also, because I was still on probation and things like that as well, you can understand why they don't want to, especially as a small business, why they don't want to go and spend thousands of pounds or something if somebody might leave in a few months' time, although technically they're putting it in place for future.
I do think that having you on probation shouldn't be an excuse, personally, because, like you say, you're future-proofing the building, and to put this stuff in place will open up the building to other employers or employees. So, for example, you said about the visual fire alarms, you may have someone who's deaf who might come for an interview, spot the visual fire alarm and go, this looks like a good place to work. They know what they're talking about. So, it's just kind of framing it like that and trying to show them that actually, if we put this in place, then it will be great for, like I say, future-proofing the business, future-proofing the building, if they decide to move on, that kind of thing.
Brilliant. Thanks, Claire. That was a really interesting, intricate question, but really useful. And I'm going to let you get back to the second bit of your talk, if that works for you, Natalie.
Yeah, of course.
Questions afterwards.
Cool. No worries. Thank you. Cool. So the next thing that I just want to talk about now is we're going to start looking at different types of discrimination and reasonable adjustments and what reasonable adjustments mean. So like I said before, I did tell you I'd be coming on to reasonable adjustments, and we are here. So as I've already mentioned, under the Equality Act 2010, it's unlawful for service providers to treat disabled people less favourably because they're disabled. So Claire, that's something to bear in mind as well, just on your question. So also service providers must not treat a disabled person unfavourably because of something connected with their disability, unless there's a clear and fair reason. For this form of discrimination, the service provider must know, or should reasonably have been expected to know, that the person is disabled. A service provider must not harass a disabled person in relation to access to everyday services. There's protection from direct disability discrimination and harassment for people who are associated with a disabled person. So, for example, a carer or a family member, or who are wrongly believed to be disabled. Service providers must make reasonable adjustments for disabled people in the way they deliver their services. This is so that a disabled person is not put at a substantial disadvantage compared to non-disabled people in accessing the same services. So I think that's a really important point to note there. There's loads of different types of discrimination, and these are all covered under the Act. So I just thought it'd be good to look at them in more detail and just kind of talk about what they mean, along with some examples. And I just want to say as well that if any of the kind of examples that I use resonate with you, please do seek support. I think for me, you know, the real point of this evening's talk is to empower you guys to be able to speak up when something isn't right. And, you know, if you're experiencing discrimination, because this is just against the Equality Act. So I could go and sit here and kind of go through each section of the Equality Act, but I wanted to give you stuff that you can take away. So it's really important to just kind of learn what types of discrimination the Equality Act can protect you from, as this can really help you in situations that you might come up against kind of in real life. So first up is direct discrimination. So this happens when someone treats you worse than another person in a similar situation because of your protected characteristic. So like I said before, for the purposes of this talk and these examples, the protected characteristic is of course disability, but bear in mind that it could be for something for being of a particular gender or being pregnant, that kind of thing as well. So just kind of bear that in mind. So an example of direct discrimination could be during an interview, a job applicant tells a potential employer that he has CP. The employer decides not to appoint him, even though he's the best candidate they have interviewed, because they assume that he will need a lot of time off sick due to his disability. So that's direct discrimination. Claire, I can see you nodding there. Indirect discrimination. So indirect discrimination happens when an organisation has a particular policy or way of working that has a worse impact on disabled people compared to people who are not disabled. So indirect discrimination is where there's no specific intention to discriminate, but a failure to consider disabled people when planning rules and policies mean disabled people are nonetheless disadvantaged or excluded. So indirect discrimination is unlawful unless the organisation or employer is able to show that there's good reason for the policy that they have in place and that it's proportionate. So this would be known as a objective justification. So an example of that would be a job advert states that all applicants must have a driving licence. This puts some disabled people at a disadvantage because they may not have a licence because, for example, they have epilepsy. So if the advert for the job is for a bus driver job, for example, the requirement will of course be justified. But if it's for a teacher to work across two schools, this will be more difficult to justify because a reasonable adjustment that could be put in place there is taxis, for example, or transport that the employer would have to put in place to travel between those two schools. The next one is harassment. So harassment occurs when someone treats you in a way that makes you feel humiliated, offended, or degraded. So, for example, a disabled woman is regularly sworn at and called names by colleagues at work because of her disability. So harassment can never be justified, full stop, can never be justified. However, if an organisation or employer can show that it did everything it could to prevent people who work for it from behaving like that, you'll not be able to make a claim for harassment against the employer, but you could make a claim against the harasser directly. So, you know, if an organisation can show that they have all these policies in place that prevent people from being a harasser, for example, if they can show that, then the claim would change and you could claim against the harasser directly rather than the organisation as a whole. The next one is victimisation. So this is when you're treated badly because you've made a complaint of discrimination under the Equality Act. So it can also occur if you're supporting someone who's made a complaint of discrimination. So, for example, an employee has made a complaint of disability discrimination. The employer threatens to sack them unless they withdraw the complaint. Or an employer threatens to sack a member of staff because he thinks she intends to support a colleague's disability discrimination claim. The next one is discrimination by association. So discrimination by association occurs when a person is treated less favourably because they're linked or associated with a protected characteristic. So the person does not have the protected characteristic, but they're treated less favourably than others because of a protected characteristic of a friend, spouse, partner, parent, or another person with whom they're associated. So it could be, say, for example, you know, I have a disability, my husband does not. So it could be discrimination by association. He could be discriminated against because of his association with me. But another example could be that Beth is refused a place at her local playgroup because the management committee know that her younger brother has cerebral palsy. They operate a policy of automatically offering places to siblings, and they're concerned that looking after her brother would take too much time. So this is direct discrimination against Beth because of her association with her brother. The next one, I apologise, it's a very long list, but I hope it's informative. The next one is discrimination by perception. So this gives legal protection for people who are mistakenly perceived to be disabled. So an example is a candidate is not offered a place on a university course because the university suspects they have a mental health condition, even though they don't, and they're concerned that they will not be able to complete the course. And the last one is failure to make reasonable adjustments. So under the Equality Act, employers and organisations have a responsibility to make sure that disabled people can access jobs, education and services as easily as non-disabled people. This is known as a duty to make reasonable adjustments. So disabled people can experience discrimination if the employer or organisation doesn't make a reasonable adjustment, and this would be known as a failure to make reasonable adjustments. For example, an employee with a mobility impairment needs a parking space close to the office. However, her employer only gives parking spaces to senior managers and refuses to give her a designated parking space. Or another one, which I'm sure we've probably all experienced, is an accessible toilet being used as a storage cupboard, so it cannot be used safely as a toilet. So what's reasonable would depend on a number of factors, including the resources available to the organisation making the adjustment. So if we look back at the parking example that I gave, so an employer with a mobility impairment needs a parking space close to the office. However, her employer only gives parking spaces to senior managers. So if an organisation already has a number of parking spaces, it would be reasonable for it to designate one close to the entrance for the employee. That's, you know, it's a pretty simple thing that they can put in place there. But there are obviously things to think about when deciding if something is reasonable. So is the change effective? Does the adjustment do what it's supposed to do? If you put the car parking space nearer to the entrance for the employee, but it's, for example, not a wider space, which is something they may require because they may be a wheelchair user, then it's unlikely to be considered a reasonable adjustment. Is the change going to be practical? So can you actually do it? So in this case, chances are, yeah, they probably can do it. Are there financial risks and are there sufficient resources available? So depending on the size of the company, what is reasonable can also change. However, just because it's a small company does not mean they do not need to think of adjustments that can be put in place. A lot of adjustments don't actually have that big a cost implication. It's just a case of planning ahead and thinking about what can be achieved. So in my kind of day-to-day job, I deal with, they're called grassroots venues. So these venues are like tiny little pubs that don't have a lot of money. So my expertise with them is to help them think of reasonable adjustments that specifically do not cost anything or have a really low cost that won't have a big effect on the business. So I just wanted to put that out there that, you know, if people just put a little bit of thought into these things, that it's easily done. It's important to note, I think I mentioned it before when we were talking in the questions, that the cost of providing reasonable adjustments cannot be passed on to the disabled person who requires those adjustments. It must be the business that foots the bill, if you like. Obviously, another thing to think about would be the extent of disruption in the day-to-day running of the business. And does it contravene health and safety laws? So this is a really important thing to note, that health and safety laws can actually trump equality legislation. However, for something to be a valid health and safety concern, so I think, Anna, it was you that was talking about the ramp and that the council was saying no to the ramp. So this would be a really important thing to note, that if something to be considered a valid health and safety concern, there needs to be that written report from someone who's appropriately qualified and experienced to do this. It's basically exactly what I was saying to you before. So, you know, a member of staff refusing an adjustment as a health and safety risk, just on a kind of ad hoc basis that's not backed up in writing, is unlikely to be operating in line with the Equality Act. A good rule of thumb, which we always kind of say to businesses, but it's also something which I think you guys can take forward when you're kind of in the open world experiencing these businesses, is how can people say yes before they say no? I think that's something that's really important to bear in mind. So this means, you know, these businesses should be thinking about all the ways they might be able to meet the adjustment that's required. If they still can't find a way to do it, then they might talk to their colleagues. And then even still, if they can't find a way, they should talk through with the customer who requires that adjustment. They might have to explain the reason why they can't do what's been requested, and talk to the customer and see if they might be able to make suggestions that the business haven't even thought of. Obviously, if they still can't find a way to do it, there may not be a reasonable adjustment that can be put in place. But businesses should not conclude something's not a reasonable adjustment until they've tried all ways to meet this. So I think for me, the kind of main reason that I've mentioned that is because if something's not right, so say, for example, like with Anna, we've got steps instead of a ramp to get into the shop. It is really easy to moan at the business, and I think, you know, we're all guilty of it, to go in all guns blazing, and after today's talk you'll go in and say, oh, this isn't right, the Equality Act, you know, and shout at the business just through sheer frustration. Like, I think we've all been there, but if they have no lived experience of disability, or they don't know anyone with a disability, they might not have even considered that that's actually a barrier. Like, I've gone to some businesses, and when we meet with these businesses, we talk to them about their venue and the outline of their venue. And some venues have got like a couple of steps down to the pit, and they didn't even realise, because they don't have to think about that, because it's just a couple of steps. So I think it's really important to remember that. And although it is hard, because obviously we're so frustrated and we want them to get this right and they're just not understanding it, I think the best thing to do would just be to take a step back and just, talk to the organisation, maybe offer to help find a solution to the barrier that's in place, because they may not see that it's a barrier. So I just wanted to say that, just to, work with these organisations, basically. As I've already said before, if something's required as a reasonable adjustment, the cost is not down to the service provider. So just following on what I've just said, if they say to you, why don't you pay for it? Then you can just say, actually, no, because that's not your responsibility. That's the business's responsibility. So if you need the adjustment in place, it's down to the business. And like I was saying with Claire, that's something which is really good to put in place anyway, because it future-proofs that building if it's a physical thing that needs to be put in place, for example. Similarly, if you work somewhere and a reasonable adjustment is required in the workplace, the cost is not the responsibility of the employee, it's up to the employer. And like we've discussed already, this is where government schemes like Access to Work can assist your employer, but there may be, depending on the different types of businesses, there may be other funding streams they may be able to tap into. Service providers and employers should ensure that anything they provide is properly maintained. Accessible toilets, for example, as I've said before, don't use them as a storeroom. I'm sure we've all seen it. Automatic doors, make sure they're in good working condition, that sort of thing, just as a kind of couple of examples. Service providers should have contingency plans in place in case the aids break. So, a failure to ensure the aid is in operation. So again, if it's an accessible toilet is broken and never fixed, or if an automatic door is never repaired, may be seen as a failure to make an adjustment. So it's all well and good if they have these in place, but if they're not looking after them, then that would be a failure to make that adjustment. So the last thing I want to talk about is just how the Equality Act applies to employers. So it's important to note that under the Equality Act, no employer of any size can discriminate against a disabled person because of their disability or something connected with their disability. So employers generally shouldn't question your disability. They can only ask about someone's disability or health condition in the following circumstances. So if the employer needs the information so they can make reasonable adjustments to a selection process, like an interview, to assist the employer to decide whether you can carry out a task that's an essential part of the work. And in that case, again, the employer has to consider those reasonable adjustments. To monitor diversity among people applying for jobs. So for example, all the work that we do is funded, and they like to have a lot of monitoring done of different diversity groups. So that's one reason they may want to capture that information. If the employer wants to increase the number of disabled people that they employ, if it's a requirement of the job that you have a disability, and also for the purposes of any kind of national security checks. As was the case under the DDA, and is still the case under the Equality Act, employers cannot discriminate against a disabled person in their terms and conditions of employment, in chances for promotion, transfer, training, or other benefits like that, by dismissing them unfairly, by treating them less fairly than other workers, by subjecting them to harassment. So service providers need to take steps to ensure that discrimination is not occurring. A service provider will be liable for unlawful acts committed by their employees unless they have taken reasonable steps to prevent such acts. So service providers can prevent their employees from discriminating against service users or customers if they do the following things. So establishing a policy. By the way, I'm just just to kind of backtrack a little bit, I'm just putting all of this in place. So if people are having difficulty in their workplace, this might be stuff that you might want to take forward to your employers and just make sure that they're putting in place. Sorry, just thought I'd preface this with that little bit of information there. So, you know, employers should establish a policy to ensure equal access to and enjoyment of their services by potential service users or customers from all groups in society. Communicate the policy to staff, ensuring that they know that it's unlawful to discriminate when they're providing services. Train all staff. This is so important. Train all staff, including those not public facing, to understand the policy, the meaning of equality in this context, and their legal obligations. Monitor the implementation and effectiveness of the policy. Address acts of discrimination by staff as part of disciplinary rules and procedures. Ensure that performance management systems address equality and non-discrimination. Maintain an easy-to-use, well-publicised complaints procedure. Review practices to ensure that they do not unjustifiably disadvantage particular groups. And the most important thing an employer can do is consult customers, staff, and organisations. So talk to people who represent these groups, who share protected characteristics. So, you know, talk to your disabled customers, talk to disabled staff, talk to other disabled organisations about the quality and equality of their services and how they could be made more inclusive and improved. I think it's really important that, you know, if your employer isn't doing any of these steps to prevent discrimination, to highlight it to them for both their sake as an employer, but also yours as an employee. Obviously, that goes for businesses you may access as well, you know, just to highlight this information to them. The Equality Act is in place to protect us as disabled people. And I just hope that this has given you some knowledge of what it protects you from and how it can assist you.
Yeah, that was amazing. Fantastic.
Thanks.
So we have catch your breath, but we have questions. So so I'm going to try and group some of the questions because they do seem to be coming up in certain areas. So one question, one group of questions was around the environment that you work in and and employers' responsibility. So if, I know you mentioned it before, but if an accessible door has stopped working, so therefore you don't get access to the staff room, for instance, how can you, and the employer says there's nothing you can do about it, they can do about it, how could you then possibly go back?
Of course, there's something they can do about it. They can fix said door. This is the real difficulty. Like, you know, it's easy for me to sit back and say, well, they should be fixing that door. But the reality is, yeah, they actually should be fixing that door because one, it's broken. So as a business, it doesn't look great if the door's broken. Two, it's an access aid. And like I said, you know, if the door is there, say like an automatic door is there and it's something that's been put in place, if it's then not working, that's a failure to provide that reasonable adjustment. So under the Equality Act, that would be something that you could bring up as discrimination. Right.
Another question around reasonable adjustments. If we're thinking about it by discrimination by association,
yes,
I think, or it's discrimination by protection, but does an employer need to make reasonable adjustments for either a spouse or a dependent of a disabled person, for instance, flexible working?
Yes, of course. Of course, yeah. Flexible working is a really big thing, and that's something which us as an organisation, you know, we're a disability-led organisation, so we're really hot on this kind of stuff. So if we have, say we employ someone, an example I can use is we've employed someone who's got a child. So on specific days, they need to leave early to be able to look after their child. So as a reasonable adjustment, it's flexible working. So it can be something that we put in place, and you can, the best thing to do would just be to talk to the employer and just be open and honest with them and tell them that this needs to be put in place.
Brilliant. So then expanding that slightly on going back to when you were talking about driving, you needing to have a license if it's appropriate. Yeah. So if in the spec of a job, it says you must be able to climb steps. So for instance, the example that was given was you work in a records office. and the records are on shelves. So you need to be able to go up to a step ladder to be able to get there. Are they allowed to put that in the spec? From a health and safety point of view, I get it, but from an equality, it means that if you're wheelchair based, you can't necessarily fulfill that role.
Yeah, of course. So I mean, you know, this is quite a difficult one, because there's kind of two questions there. So are they allowed to put it in the spec? Yeah, you know, they can put that in the spec if they want to. However, if they do have applications from disabled people for, like, say, for example, a wheelchair user, and it just so happens that the wheelchair user is the best person for the job, then they would need to put in those reasonable adjustments to enable them to do that job. Does that make sense?
Yeah, thank you. I'm going to invite Robin to ask her question. Where's Robin? There you go, Robin. What's your question for Nat?
Hello. What it was is when you was on about the work placement difficulty, I actually did have a difficult whatever it is. I can't say it now. What it was is I was at Primark, the tills wasn't working whatsoever. This was like before Christmas. I didn't know what to do. I was supposed to be on the tills, but it wasn't working. I couldn't know what to do. It's like they asked me to go on the shop floor. It's like, what am I doing? I really no idea. Is there any ideas what I could help with?
So I'd say in that situation, you know, if it's something that you're not comfortable doing, definitely communicating that to your work and telling them that you're not comfortable. And if you're not sure what to do, definitely ask.
Okay.
It's like I do ask, but they don't do anything about it. It's like,
Is it in this situation actually, Nat, would it be useful for them to document it to you, like in an email, so that you've got evidence of that?
Yeah, definitely. I think discussions when it comes to the workplace is definitely best to have it, I was going to say paper-based, but it's not, like electronic, like written down is probably the best thing to have. So you've got kind of that trail that you can go back for your sake to look on. And also when they say, oh, we didn't say this, then you can say, actually, yeah, you did.
So there's another scenario. Sorry, Dave, do you want to ask your question? Oh, you're on mute, Dave. Oh, there you go.
Hiya. So it just goes back to what you were just saying about things being in a job spec. Because I'm in an admin job at the moment, which I'm fine with. But quite a few years ago, I went to York Hospital for an interview for what was supposed to be an admin job. In the orthotics department, and I know that and the job description just said various things to do with admin. So I thought I'd be suitable to apply, but also they offered that thing where you can tick it, and if you meet the minimum criteria. That people with disabilities can be automatically invited for interview. But then, like, one of the very first things, and on my application, I'd put about having a disability and cerebral palsy and so forth. And when I went in, the very first question in the interview was. Because it was to do with orthotics, which obviously shoes. And the very first question was, a lot of the job is lugging heavy trolleys around with shoes on. Will that be a problem? And so I tried to answer it the best I could, because obviously it would have been, because I've only got use of one hand fully, and I wouldn't have been able to sort of maneuver the trolleys and get through the doors properly. So immediately I felt like it was a waste of time me being there, and so I kind of switched off for the rest of the interview, and I had a rejection by the end of that day. And I just wonder if that's something that they should have taken more into account before inviting me, or that they should have put that in the description, that because if they'd put in the description that the vast majority of it was going to be humping large trolleys of shoes round, I would have never have wasted my time applying.
So I think, in that situation, they should have put it on the description, on the job description, like on the job spec, because there's value in having it in there, and that way you as a disabled person, you can make that informed choice. Like you just said, if you'd had seen that on there, you wouldn't have even applied. So it's it's one of those things that they can put it on there, you might decide to apply it, and if you do come out as being, like I said before, the best person who's suited for the job, but there would be that barrier of lugging these boxes around, then they can put something in place to assist you with that. So like, just off the top of my head, thinking to like festivals and stuff, because when we do festival working, I have to lug big boxes around, which it's not fun, but it's a part of the job. So we have like trolleys and stuff that we can use, so they might have been able to put like a trolley in place that would help you to do that. But they should, I think ultimately they should have put that in the job description as well, so you knew that it was coming, because especially if that's the first question they ask. I've been to a lot of interviews, and if the first question just turns you off, then that's it.
So is there anything, I'm guessing there's nothing like legal that sort of would make them have to put that in the job description?
I mean, not necessarily, no. Like, they should have put it in there for transparency, so that you knew it was part of the job, especially if in just thinking about it, if it's the first question they ask. In my head, I'm thinking, actually, that's probably a really big part of the job then, if that's the very first thing that they ask. So that should have been part of the job description.
Right, fair enough. I just was wanting some some thoughts on it.
Yeah, of course, no worries.
Sure.
Thanks, Dave. So I just wanted to acknowledge that we are slightly over time, but I do have 3 more questions to ask, if everyone's okay. Nat, if you're okay to continue just a little bit. So just going back to the reasonable adjustments, does that include the cost of a PA or a carer, is one question.
So it depends in what context. So, for example, if it's to be able to access work, a colleague of mine has her PA for work hours funded by Access to Work. So, but obviously, if it's for your own kind of personal thing, then probably not.
Brilliant, that's very clear. The next question is around. Somebody had a scenario where they were they'd asked for shorter hours at work, but they weren't given it, and then they ended up having to go off unwell, and then when they came back, they were then given the shorter hours. But initially, the employer was threatening to dock their wages if they took time off for rest periods during the day. So obviously now they had that time off sick, and now they've got the rest times. But how could that person have dealt with that scenario in maybe a more constructive way?
So is the time off connected to the disability? This is
not connected with the burnout, because they weren't having the rest times.
Okay, so that would be something that is obviously discrimination, and they would need to bring up with their employer. And again, I know I keep saying it like it's just something really easy to do, and I appreciate it's really difficult to talk to employers, especially if they're like big companies, but you do need to talk to them and say to them, you know, this is against the Equality Act and it's discrimination, and I need the support here. And just talking to them and just being really frank and open, I think is really important in this situation. I think that helps. Brilliant.
Okay. Another one about which brings you back to your home area, which is gigs and venues. Wheelchair users that want to go with their friends who are also wheelchair users, but find it really difficult to book venues together. How can one navigate that?
Talk to the venue. Obviously, it's dependent on the venue. So just off the top of my head, somewhere like Wembley Arena, that's something they can absolutely accommodate. There might be a small, so I go to a lot of like small punk gigs in little pubs, which they may not be able to accommodate because 2 wheelchair users is probably going to be half of the venue taken up by people. So it's, I think the biggest thing you can do is talk to the venue and say, this is the situation, I'm coming with my friends. Because of course, you know, this is one of the big things that we always say, disabled people have friends. Disabled people want to access this stuff with their friends. And if their friends are in a wheelchair too, then, you know, so what? Like, they have to make those adjustments for them. So making sure, I find, you know, you can kind of just go online and book the tickets, but if you actually engage in that conversation and talk to the venue, most of them are really open and can help. But again, my email address is in the chat, so if you have any problems with venues and stuff, drop me an email.
I'm going to put it up at the end of the talk. I've copied it, so it will come up at the bottom of the chat as well, so you don't have to
fine.
Cool. So one last question, which is, can the employer access the Access to Work fund for support at work without it reducing the direct payment that you receive?
I would say yes, to be honest, because it's work related, and you know, you need that support is for work. I'm not particularly like kind of au fait with direct payments and stuff, but thinking about the way that I've used Access to Work in the past, that's a separate entity, so that's a separate thing, so they should be able to do that. But if you're not sure, talk to Access to Work, because you can just ring them and ask them and they will be able to advise.
Amazing. I'm just putting for everybody Nat's email again at the bottom.
I apologise, it's very long.
So I'd just like to say thank you so much, Natalie. It's been an incredibly useful evening, and the flurry of late questions and people's hands up kind of is testament to that. If you have a question that hasn't been answered, please drop us a line at adultcphub.org, info@. Miriam will put our email at the bottom for you. If you've got any other questions that you want to give to Nat that isn't related to gigs and her area of expertise, then we'll make sure that she gets those questions and we can get them answered for you. But thank you very, very much for coming this evening. I just wanted to tell you about our next Chatting With, which is on the 21st of March, so a month today. And we are going to be talking about sleep and sleep hygiene. That's come up quite a lot in the last few weeks, people having difficulties with their sleep. So we thought we'd take you right back down to basics and have a conversation with Jackie McTaggart, who is a mental health nurse, who's going to talk to us about sleep hygiene. And later on in the week, we shall post the event, and we shall post the link to the Eventbrite. So we hope that you'll all join us then. And I think that's all that we've got to say. Thank you for staying a little bit extra. I hope you think it was worth it. We have recorded it this evening, and we'll put it up on YouTube as soon as we possibly can. So thank you, and we'll see you soon.